Good afternoon, everybody. Thank you for joining us for the law school's second town hall on the COVID-19 pandemic. This week discussing COVID-19, disability, civil rights, and healthcare rationing. Our speakers this afternoon are Samuel Bagenstos, the Frank G. Millard Professor of Law at the University of Michigan Law School, and Mary Crossley, the John E. Murray Faculty Scholar and Professor of Law at the University of Pittsburgh School of Law. My name is David Moss. I'm an Associate Clinical Professor here at Wayne State and Director of the law school's Disability Law Clinic. Professor Bagenstos is widely regarded as one of the leading scholars and practitioners in the field of disability civil rights law. From 2009 to 2011, he served as the Principal Deputy Assistant Attorney General for Civil Rights at the U.S. Department of Justice, the #2 official in the Civil Rights Division. His accomplishments there included promulgating the first comprehensive update of the Justice Department's regulations interpreting the ADA and reinvigorating the Civil Rights Division's enforcement of Olmstead versus LC, which guarantees people with disabilities the right to live and receive services in the most integrated setting appropriate. He has argued major disability civil rights cases before the U.S. Supreme Court, including United States versus Georgia and Fry versus Napoleon Community Schools. As an academic, Professor Bagenstos has published articles in journals such as the Yale Law Journal, the Stanford Law Review, the Columbia Law Review, and many others. He has published 2 books, Law and the Contradictions of the Disability Rights Movement, and Disability Law, Cases and Materials, which just happens to be the principal text for the disability law course that I'm teaching here at Wayne State. Professor Crossley is a leading scholar in the fields of health law, bioethics in the law, and disability civil rights law. Her scholarship is focused on issues of inequality in the financing and delivery of healthcare, addressing topics ranging from how health insurance discriminates against unhealthy people to how hospitals' community needs assessments can be used to address racial health disparities. She has published broadly in journals including the Columbia Law Review, the Notre Dame Law Review, and the Michigan Journal of Race and Law. Professor Crossley served as Dean of the University of Pittsburgh School of Law from 2005 to 2012. In 2016, she was elected to the American Law Institute. Before I hand things off to Professor Bagenstos, I'd like to go over a few housekeeping items for using Zoom. First, please use the raise hand feature if you have a question, or if you prefer, submit questions using the chat feature. We'll give Professors Bagenstos and Crossley about 15 to 20 minutes each to talk without interruption, and then I'll call people who've raised their hands and read questions that have been submitted using the chat feature. Second, please keep your mic muted when called on to ask a question, except when called on to ask a question. And third, please keep your cameras on unless you have a good reason for turning it off. One of the goals of these town halls is to help us maintain a sense of community, and it's hard to do that when we can't see each other. Lastly, please note that our next town hall will be next Wednesday, April 15th, starting at 12:15 p.m. The topic will be constitutional law and the coronavirus, from abortion rights to quarantines. Our speakers will be Professor Lindsay Wiley from American University, Professor Anthony Kreis from Chicago, Kent, and Professor Jonathan Weinberg from Wayne State. With that, I'll pass the torch to Professor Bagenstos and let him take it from here.
All right, great. Well, thanks so much. It's really great to be a part of this. I wish that we could be at Wayne State in person. I love doing things at Wayne State. It's a great community there of both scholars and students. And I really appreciate the chance to talk on this, particularly with Mary Crossley, who, when I was getting my start 20-something years ago as a scholar in disability rights. I was one of the people who'd written a lot of the work that I really relied on and learned so much from. So I'm particularly enjoying that, notwithstanding these very strange and difficult times. What I wanted to do, just to kind of set this up, and I have 15 to 20 minutes. Hopefully I won't take the whole time. I probably will, but I'm going to try not to. I want to kind of give a sense of what the issue is that we're talking about here, both in terms of the factual issue, what's going on in the world on this issue, and in terms of some of the legal and ethical questions here. And I should let you know, in addition to this being something I've written about in my scholarly capacity, I've also done a fair amount of advocacy on this and am counsel on complaints against 5 states before the Office for Civil Rights of the U.S. Department of Health and Human Services, challenging various rationing protocols that are used by, or at least that have been promulgated by states in advance of this. So effectively, the biggest picture here is we are in the middle of this pandemic. We expect that there is going to be a surge of patients in our hospitals. You see, in Michigan, we're already building excess hospital capacity in convention centers. We're building excess hospital capacity in dorms, in universities, because we have the sense that once the numbers get to a particular point, the hospitals will be above capacity, and so we need more. And in particular, for people who will have the coronavirus most severely, they're likely to need particular kinds of life-saving treatment, particularly ventilators. And there's a limited number of ventilators. That is the result of a bunch of decisions that have been made through the years. And I want to get back to that, but it's not a natural fact. That is a fact that results from decisions not to invest in creating capacity for a surge in demand for ventilators. And this is something that was anticipated. This is something that people have talked about. This is something that in fact, public policy had moved toward trying to do after various pandemics in the past. But we did not do that sufficiently. And so we're expecting we're going to have not enough ventilators to go around. And that's going to mean that at the moment we have too many people seeking life-saving care, there won't be the ability to save all of their lives. Even if they could be fully treated, even if they could survive if they got the treatment's just not going to be there. And so in that context, doctors, hospitals, health systems have to make decisions about how to allocate the life-saving treatment. And as part of an effort to make sure that this isn't being done on an ad hoc basis, by the bedside, by people who are overwhelmed with information and emotion, doctors want to save everybody. They don't want to decide to let people die. That's not the way they're trained. That's not the orientation they have. As part of an effort to make sure that there are rules in advance, the health systems have these protocols, these crisis standards of care, they're called, which kind of kick in at a moment when there are just too many people seeking too few services, essentially. And they try to decide how to ration. And unfortunately, from my perspective, and from a disability rights perspective, I believe, unfortunately, what a lot of these crisis standards of care do is they allocate scarce ventilators to people based on a bunch of factors, including the existence of pre-existing disabilities. And that's the particular thing that we've been focused on, that we're going to talk about today, and that I've been focused on in advocacy and writing over the past couple of weeks. And so in particular, I think it's important to separate out 2 things. So if a person has a disability before they acquire coronavirus, and that disability makes it harder for them to actually recover from coronavirus, interferes with treatment for coronavirus, or otherwise makes the coronavirus case worse in a way that it can't be treated. Virtually nobody thinks that choosing to save someone else who's more likely to be successfully treated for the immediate coronavirus is disability discrimination, right? So long as there's a relationship between the underlying disability, you know, which could be some kind of heart disease, it could be something else, but the underlying disability and the likelihood of recovering in the immediate term from treatment, virtually nobody thinks that taking that into account in a case where you have to take something into account is disability discrimination. A slightly harder case is someone who has a pre-existing disability that is going to kill them in the immediate term one way or the other, whether or not the coronavirus treatment is successful. So the coronavirus treatment might well succeed in the sense of getting rid of the coronavirus, but say the person has extremely advanced cancer and is going to die tomorrow anyway, or die in 2 weeks anyway. Again, pretty much everybody would say a doctor who has 2 patients and 1 ventilator, so can only save one of them, should save the person who's not going to die tomorrow anyway, right? That's sort of classic battlefield triage. Unfortunately, the battlefield triage metaphor here gets extended way beyond those narrow situations and informs these crisis standards of care that various states have. And I'm just going to give you a sense of what a couple of them are. So Alabama, until they pulled this off their website, but as far as we know, this is still in effect in Alabama. Alabama, as of a couple of weeks ago on their website, said that in deciding whether to give scarce ventilator treatment, they shouldn't offer mechanical ventilator support for patients with a variety of conditions, which included and I'm just going to quote, severe or profound mental retardation. That's the language. It's not obviously the language that is acceptable or preferred these days, as well as other kinds of mental disabilities. In Washington State, which is another place where I was involved in filing a complaint, the state determined that in deciding whether to give scarce ventilator treatments, doctors should consider someone's baseline functional status. So if they have less energy or less cognition or less physical ability, they should go below in the queue someone else who has more cognition, more ability, more energy. In some states, for example, Florida says that people who have complex disorders where they're expected to need lifelong assistance with activities of daily living should be deprioritized for life-saving interventions. So you'll notice these are not about whether the person can recover from coronavirus, and they're not about whether the person is going to die anyway in the immediate term, so giving the coronavirus treatment would be futile. Instead, what these are about is essentially making judgments about the value of saving their life versus saving someone else's based on an underlying disability. And these judgments are usually based on one of 2 things once you unpack them. I mean, because these are protocols designed to be applied in a relatively automatic manner by doctors and hospital administrators, right? They don't tend to get very deep into requiring a lot of judgments by the doctors and hospitals, right? It's sort of diagnosis based, but it's not based on saying, what do you think about the factors I'm about to talk about, doctor? But the factors that underlie the valuing of saving some lives over others tend to be either based on predictions about how long someone will live, so the expected quantity of life or the life expectancy, as well as assessments about the quality of life. And so there's this underlying sense that many people have that what we ought to do is either maximize the number of years of life that are saved by scarce life-saving interventions, or maximize the number of quality adjusted life years that are saved. One way or another. And most of these protocols don't require a doctor to make the life years or quality adjusted life years calculation themselves, but they're based on that understanding. And so a couple problems with this that suggest why we have disability discrimination laws that ought to apply here and that do apply here. It's clear that the ADA, the Rehabilitation Act, and Section 1557 of the Affordable Care Act all prohibit disability discrimination in these kinds of medical decisions. The scope of them is slightly different for each statute, but as far as we're concerned, essentially the same thing. And why do we prohibit disability discrimination in these kinds of decisions? Well, because, let me start with the quality of life judgments. Quality of life judgments made by non-disabled professionals are likely to be biased. They're likely to be informed by either explicit or implicit, conscious or unconscious bias about the quality of living a life with a disability. One thing we've seen consistently in studies through the years is that when you ask people with a whole variety of disabilities what their lives are like, what's the quality of their lives, when you observe people with a whole variety of disabilities and see what they do when they get sufficient supports and are not kind of locked in their homes because of social decisions, what you see is self-reporting and observation of people living full lives. But when you ask non-disabled people what's the quality of life with a disability, consistently they say it's terrible, right? And so that's a persistent divide. And the medical profession, like most institutions where people are powerful in the United States, the medical profession substantially underrepresents disabled people. And there are a lot of reasons for that I could go into. But so to allow these quality of life judgments to justify a disability-based refusal to give someone treatment that will benefit them in the immediate sense is to allow the kind of disability discrimination, disability bias that we have these laws for. Well, what about number of years? I mean, a lot of people say, okay, fine, we get that. And actually a number of bioethicists now, in response to the latest crisis, have said, you know, ordinarily we might argue for taking account of quality of life, but in the context of a crisis, it's just too hard to figure, which I think is important. But they say we should still think about what's the greatest expected number of years saved. And of course, the problem here is this is influenced by bias as well, and it's biases of a couple of kinds, right? So one kind of bias is the predictive bias by doctors. Every disabled person I know, every family member of a disabled person I know can tell a story about a medical professional who gave a prognosis about their condition that was unduly negative, about their likelihood of achieving some function, about their likelihood of surviving very often. Right, so there's bias with regard to how long people predict folks will live. But also there's a very significant concern about even using these quantity of life, these actuarial measures in the first place, because part of the reason for that is like, even if we can get rid of all the bias in a doctor's judgment, part of the reason for the actuarial difference among different groups has to do with societal biases. And I want you to reflect for a second. Think about this. If a doctor were to say, look, we have two people coming seeking the same life-saving treatment, we can only give it to one of them. And one of them is African-American and one of them is white. And when I consult actuarial tables, I find that the African-American is likely to live for not as long, and I have to maximize the number of life years I save. Right? We all know that that is about many societal injustices and decisions, and it would merely compound the injustice to say to somebody, hey, you get to live your life and experience all the injustices that make it harder for you to have for you to have an adequate health status. And then once we're in a moment of scarcity, because of a bunch of social decisions that you probably didn't have full access to, right? Because we didn't invest in ventilators, we're going to deny you the treatment in part as a result of the harm you've already suffered because of discrimination and injustice in society. And the disability discrimination laws, we can have a lot of arguments as race the same as disability, you know, normatively. The disability discrimination laws reflect a view that disability is an axis of discrimination that we want to prohibit discrimination based on. And so to that extent, again, there's a significant concern here. Okay, so I told you I wouldn't talk 15, 20 minutes. I did. Sorry. I'm gonna turn it over to Mary. I think I've kind of laid out the issues nicely. So thanks very much again for listening to me.
Great. Thanks, Sam, and thanks to David and the other folks at Wayne State for organizing this. I think it's an important conversation for us to be having right now, and I'll try not to tread too much on the same ground that Sam has already covered, but I think what I'd like to do is to do several things, kind of start by zooming out and thinking about how the question that we're focusing on now really is a question that is situated in a broader context of how society responds to emergency situations and considers or doesn't consider people with disabilities, and then zoom in and talk a little bit about specific policy, rationing policy that I think highlights some of the concerns that Sam has raised, as well as addresses at least some of them, and I think is worth taking a look at, and then kind of zooming back out and conclude by offering a few thoughts about the importance in an emergency of committing to a just approach that recognizes both kind of intersectionality among different communities as well as commonalities of experience when we look at different marginalized communities. So when we think about rationing resources like ventilators in a pandemic, we're really just looking at a specific instance of a more general problem regarding public health preparedness, planning for emergencies. And there's a too common failure in that planning to include people with disabilities in the planning process, both in the sense of whether the distinctive needs of people with disabilities are taken into account in the planning process, as well as whether people with disabilities are actually included at the metaphorical or physical table where the planning's going on, right? Because public health emergencies that might require rationing can arise in a number of different ways, not just pandemics, right? They can follow a natural disaster like Hurricane Katrina or Hurricane Maria, both of which were particularly devastating for people with disabilities. Or they can arise in the context of the recent wildfires in California, which had a disproportionate impact on people with disabilities who rely on electrically powered medical devices. And so those folks were affected not just by the wildfires themselves, but by the decision of PG&E to engage in rolling blackouts during the fire season. And both state and federal legislation directs public health and emergency officials to take into account the needs of people with disabilities explicitly when they're planning for public health emergencies. But there really has not been much specific guidance from the federal or state governments on the crucial question of how to allocate scarce medical resources in the event of a widespread public health emergency. But while some of that planning, probably when you're not in the middle of an emergency, may seem kind of theoretical, this is not the first time that there has been kind of a live question, a non-theoretical question about rationing and disability rights. So in the early 1990s, shortly after the ADA was enacted, the Federal Department of Health and Human Services rejected an application for a Medicaid waiver from the state of Oregon that would have allowed the state to implement a rationing scheme as part of its Medicaid program. So this was not in any kind of emergency context. Instead, Oregon wanted to be able to ration care on an ongoing basis as a way of maximizing the benefits from its Medicaid program and containing costs. And the Secretary of Health and Human Services at the time, Louis Sullivan, he gave as a reason for rejecting the Oregon plan was that he believed that Oregon had relied, that Oregon had relied on telephone surveys of the general public in a way that the secretary believed may have, in his terms, quantified stereotypic assumptions about the value of life with a disability as compared to life without a disability. And that as a consequence, the resulting rankings may have devalued treatments that would have saved life, but would not have returned the patient to full functioning. At the time, Sullivan said to Oregon, okay, you can try again, right? I'm not gonna let you do it the way you planned to initially. You can try again, and you can consider, consistently with the ADA, any content neutral factor that doesn't take disability into account, or that doesn't have a particular exclusionary effect on persons with disabilities. So you can think about what those alternative content neutral factors might be. I mean, you might have a true first come, first served approach. In a situation where you have multiple people who need a ventilator and only one person or only one ventilator available, you might have some kind of lottery. You might, as some of the policies are now doing, you might have a system that gives some preference to people who are on the front lines in the healthcare system as a way of maximizing their ability to care for patients broadly. But these really aren't the approaches that healthcare systems or states have tended to take. And I think Sam has explained well why a number of the guidelines that have been produced and reported on are problematic. So I want to zoom in now and focus a little bit on a specific framework that has come out of the work of a number of people working together to put together a proposed hospital framework for allocating scarce critical care resources. And particularly Doug White, who is a colleague of mine at Pitt, and Bernard Lowe from UCSF published a piece in JAMA in late March that really at its core is utilitarian, right? This approach seeks to maximize the life years saved in the decisions that it makes, but it's not purely utilitarian. It takes justice concerns and disability rights concerns seriously. And the framework that they have published has evolved over time. So the piece that they initially published in JAMA is been updated based on conversations with people about concerns, for example, from the disability community. You can find the current version of the policy by Googling model hospital policy for allocating scarce critical care resources. And so I just want to highlight several notable points about this policy that illustrate how the drafters have really sought to incorporate disability concerns. So the policy is really very explicit about it does not include any kind of categorical exclusions of people with particular medical conditions or people with particular disabilities. So there are no categorical exclusions. In addition, it's explicit that quality of life assessments or judgments of worth should not be part of any decision that's made. The policy also emphasizes that allocative decisions about who should receive resources should be based on individualized assessments of patients, based on the best available objective medical evidence. And including this language, the policy really seeks to include and incorporate a central pillar of disability rights jurisprudence, which emphasizes the importance of individualized assessments of individuals so that stereotypes don't come into play. And then finally, the policy also articulates a process that involves a triage team within a hospital that applies the framework to try to ensure some kind of consistency, as well as a limited appeals process. And I think this is important rather than leaving it up to individual doctors on the bedside, working at the bedside. I've seen some hospitals talking about how they want individual doctors to exercise critical judgment on their own about whom to intubate or whom to put on a ventilator. And I think that kind of process of leaving it to the doctor at the bedside, as Sam mentioned, is a process that really creates conditions ripe for the operation of implicit or explicit bias. And so, I think as a starting point, what I will call the Pittsburgh framework impresses me as a serious and a good faith effort to address disability concerns. And for that, I applaud it. But I think that there are aspects of it about which disability rights advocates may still have a question. And that's with respect to taking patients' likely survival into account. And I want to just, here I'll touch a little bit on some of the points that Sam made before to make sure that I can situate this, what the Pittsburgh framework does in context, right? So there are a number of ways to take survival into account, right? One way would be to really just focus on immediate term survival. Will this patient survive until they are discharged from the hospital? whether because their survival is limited by their inability to be successfully treated for COVID-19, or because they have some other kind of condition that means even if they might be successfully treated for COVID-19, they would die for other reasons before they could be discharged. And you know, Sam made the point, and I think that there maybe perhaps is not universal agreement, but probably broad agreement that kind of immediate term survival is okay to take into account. You know, on the other end of the spectrum, you could think about looking at really long-term survival, thinking about over a longer horizon, how long will this person live? How many life years will providing a ventilator save if we give it to this patient? And I think that to deny resources to a patient whose life expectancy may be foreshortened by some other medical condition that's a disability, that's going to disadvantage both people with disabilities and potentially, as Sam points out, members of other marginalized groups who have shorter life expectancies because of social determinants of health. And in this kind of long-term look at survival, I think it's much easier to make a case that doing so would, to go back to Secretary Sullivan's language, have a particular exclusionary effect on people with disabilities, or to use the language of lawyers, it would have a disparate impact on people with disabilities. So the Pittsburgh framework that I've been talking about it takes a middle path, right? It has this scoring system that takes into account what's referred to as a SOFA score, which is really a score that numerically quantifies the number and severity of failed organs in the patient, and that I think they're really using as a way kind of estimating likelihood of surviving hospitalization. But this proposed framework also takes into account whether a patient who needs a ventilator has a medical prognosis of likely death within a year, even if they survive COVID-19, and also takes into account whether the patient has a medical prognosis of likely death within 5 years, even if they survive COVID-19. And they give the 5-year life expectancy less weight than the 1-year life expectancy in making the allocation decision. And so, you know, it's the question, I think, is, has it gone too far in considering life expectancy? You know, if you take a look at the complaint that Washington Disability Rights filed with the Office of Civil Rights at HHS, it argues that any kind of survival-based criteria has to be based on surviving the health threat that the treatment is meant to address, meaning COVID-19. And it has to be clear from the person's individual circumstances that they would die in the very near term, very short term, in order for survival to be considered. So I'd be interested in Sam's perspective during the Q&A, perhaps, on this question of some kind of weighted, sliding scale weighting of survivability. But I guess just to take a few more minutes to zoom back out again from this proposed framework, is to return to what I think are really not so much legal questions as much as ethical and policy questions about broader justice concerns. And here I think it's really important for us to think about what we want our legacy to be coming out of this crisis. There will be another side when we come out of this. And in late March, the Office of Civil Rights in Health and Human Services put out a guidance that doesn't address specifically the use of life expectancy as a basis for allocation, but it includes a statement from Roger Severino, who's the director of OCR, that says, quote, "Our civil rights laws protect the equal dignity of every human life from ruthless utilitarianism," close quote. And so I think we really, doesn't say you can't be utilitarian at all, but you can't be ruthlessly utilitarian. And so I think we have to think about how best to balance utilitarian approaches against egalitarian approaches. And I think there's an argument to be made that in allocating scarce resources in a pandemic health emergency, we should give more weight to protecting those persons who were already disadvantaged by pre-pandemic social and political decisions, right? People with disabilities endure persistent disadvantages in society. They have significantly higher poverty rates and unemployment rates. They experience disabilities, both with respect to health care and their health status. As Sam points out in his paper and also in his remarks, they're underrepresented in both political roles and in the medical profession. And so I kind of think we have to be careful not to use policies that shield non-disabled people from feeling the worst pain that flows from political decisions, both pre-pandemic and current, not to maintain a quantity of ventilators and other resources that would be adequate to meet the needs of everyone, both disabled and non-disabled, during a pandemic, and not to take more aggressive and effective actions to ramp up production and efficient distribution during the pandemic. You know, if we adopt a policy that looks at 5-year life expectancy, are we endorsing a policy that lets non-disabled folks who are likely to survive to hospital discharge off the hook, or at least off the worst hook, while folks who have disabling conditions that limit their prognosis to less than 5 years, of course, keeping in mind the concern about predictive bias and societal bias that Sam raised, are we putting the burden on people who have those kind of disabling conditions? I also think it's really important to be cognizant of the significant overlap between people with disabilities and other communities who've suffered disadvantage, right? So women have higher rates of disability than do men. And Black people have higher rates of disability than do white people. I mean, just in the past few days, we've heard reporting about higher rates of deaths among Black patients as compared to white patients in cities like New Orleans, Milwaukee, Chicago. And when we look at the South generally, we see a region that has higher uninsured rates among low-income Blacks largely because of the state's political decisions to refuse to adopt the Medicaid expansion. And when we look at the South, we are already seeing and anticipate seeing particularly ravaging effects of the bias. So I think if we're serious about having a more just healthcare system after the pandemic, once we get to the other side, if we're serious about decreasing health disparities for Black people and people with disabilities, I think we really need to think about how our decisions now will affect our ability to accomplish those policy goals. And one thing that we know is that mistrust of the medical profession is one of the factors that contributes to health disparities. And so are we going to make a decision now that is going to further erode trust in the health system and the medical profession? Or could we actually have an approach now that increases trust and would help us save more lives following the pandemic? So I'll just end by putting in a plug for an approach to protecting civil rights for people with disabilities in the context of rationing decisions that also seeks to foster solidarity with other marginalized groups. And I'll stop there.
Thank you, Sam and Mary. There, I'm unmuted now. Thank you, Sam and Mary. If people would like to ask questions, please use the raise hands feature. I don't have it on my screen, but I think that if you go to the Manage Participants list and go next to your name, there should be a place where you can raise your hand if you have a question, or you can submit questions via the chat feature. Mary, somebody asked if you would share again the link to the rationing criteria that are being used in Pennsylvania.
Yeah, so I don't have the specific link, but I got the most current version by Googling model hospital policy for allocating scarce critical care resources. So it's model hospital policy for allocating scarce critical care resources.
And while we're waiting for some questions, I'll start off with a few. One is, to what extent does it matter in this discussion that a majority of people with COVID-19 who need mechanical ventilation don't survive to discharge from the hospital. So the most recent statistics that I've been seeing, both based on China's experience and Italy's experience and the New York experience, is that about 2/3 of the people who receive mechanical ventilation don't survive to discharge. Does that affect the analysis at all?
So I don't know whether Mary wants to say anything about that. I mean, so a couple of things I'd say, probably it doesn't at some level. I mean, if what we're talking about is just, it's a lower chance of success of the treatment overall. Some of it though, it's a little bit hard to tell. Of course, we are in the midst of this crisis happening and trying to figure out what the information means that we're getting. And so some of it might well be that because there are so few ventilators, people are waiting to put people on ventilators until they are at a particular stage, which might make it harder for them to survive. I think we're still learning a lot about the virus and about how it progresses in people. And it seems like we learn more about that every day, but I'm not sure that makes a difference unless we can say something about what kinds of conditions make the ventilator treatment more or less likely to work in the sense of actually curing, aiding in recovery from coronavirus.
Yeah, I would agree that I don't see that it makes any big difference. I think a couple of points worth keeping in mind. One is that, what you're saying, David, is that what we know right now, which is still limited, is that in a sense, we need to be thinking of ventilators for treating COVID-19 as, I don't want to say last ditch, but closer to last ditch than they would normally be in medical practice, right? Because of the nature of the disease and how severely it damages the lungs. By the time they put a person on the ventilator, it's less likely to be successful. And the other thing, and this actually is not relevant to, I don't think, the application of disability discrimination laws, but just from a practical perspective, people who have COVID-19 who are put on ventilators are needing to stay on them longer than ordinarily someone who's in the ICU for some other condition who might need to be put on a ventilator temporarily would need to. And that simply means that it increases the scarcity of ventilators because people aren't able to come off of them as fast. So for example, in the proposed framework that I talked about out of Pittsburgh, they also have steps for reassessing, right? So somebody's on a ventilator, should they stay on the ventilator, or should they come off because their condition is declining even though they are on a ventilator? And so particularly in light of the fact that a majority of people don't survive to discharge once they're put on a ventilator, that may be a basis for saying, okay, we need to ease them off and make the ventilator available to someone else.
Another question. Does it make a difference? Does it matter that most people who require mechanical ventilation with COVID-19 have underlying conditions such as diabetes or hypertension or cardiovascular complications that are disabilities under the ADA in Section 504? That the reason why most people need mechanical ventilation is related to the underlying disability.
Yeah, I mean, I think that's important. And what a number of folks who are defending the use of disability as a basis for denying certain people life-saving treatment in the rationing context are saying is essentially, look, you're actually going to save more people with disabilities if you maximize the number of lives saved, because these are all people with disabilities. And I think the way that we tend to think about discrimination laws and the way we apply discrimination laws is much more individualistic than that. And I think it makes sense given the broad array of different kinds of disabilities. The definition of disability under the ADA, particularly after the ADA amendments in 2008, really covers an enormous array of people. who have very different kinds of conditions and very different experiences with regard to the, the biases they face, with barriers they faced, et cetera. The way discrimination laws tend to focus is not on, let's look at the ultimate distribution of the decision of the overall policy, but let's look at the decision and what is the basis of this decision that's being made to deny a particular opportunity to a particular person, and where the basis of the decision is because you have a disability that is not connected to your ability to recover, you are going to be deprioritized for a condition. That's where I think we have the disability discrimination problem. And that's true, even if there are people with disabilities on, other kinds of disabilities, other conditions on the other side. And again, if we think about this in terms of race or sex discrimination, it may be evidence that they're not using race or sex if an employer promotes people of a particular race or sex and doesn't promote this person who has the same race or sex. Maybe we think there's no intent, there's no classification there, there's no disparate treatment. But if we know that this employer is refusing to hire this person because they're a woman or because they're a person with a disability, then the fact that there are other people who are women or with disabilities have benefited, that doesn't undermine the claim of discrimination. So as far as thinking about the application of the law, I think that is not really, again, something that's dispositive. But, I agree. I think it highlights the real importance of the thing I started with, or came close to starting with, which is if you really want to take disability seriously here, you have to be thinking about this in terms of the investments you make in the healthcare system, both for regular healthcare and for the capacity to be prepared for a surge in needs. And we didn't do that. And so that is in itself a kind of disability discrimination that it's important to note. And I think when Mary says that, we have to be really worried here that we're essentially letting everybody off the hook. So if I don't have a disability, I can say, yeah, look, I don't need any of these healthcare services because those are only for people with disabilities. And then we don't invest in them because people like me decide we're not going to do that. And then all of a sudden, there are two of us who need the care and it will save our lives. And I say, well, sorry, disabled person, you don't get it because you're not going to live as long anyway, in part because of the decisions I made before. That is not the way to structure a just society over time. So, I totally endorse what Mary was saying there. So I think that raises this issue very strongly.
Yeah, and I guess, it's this odd thing about discrimination or anti-discrimination law where you do want to, particularly in the context of disability, you do want to focus on the individual so that there's an individualized assessment to, as I said before, not rely on stereotypes about people with disabilities. And so you want to have an individualized assessment, but it is also true that aside from an individualized treatment decision or rationing decision not to provide potentially life-saving treatment, can be a form of discrimination, but so can the use of factors in decision-making that have a disparate impact on people with disabilities as a group. And so, as I've been trying to think about this, I think about if you have a policy that takes, again, just to use this example, 5-year survival into account, 5-year life expectancy into account. If you had a gallery of pictures, kind of like on a Zoom meeting, of people who received ventilator care and lived, and people who were denied ventilator care under the policy and died, would there be a more kind of disproportionate representation of people with disabilities in that second group? And I have to suppose that I think there would be. Now, I've had conversations with Doug White, who's part of the group that put together this framework, who's very thoughtful. And, he's provided me with examples of people who would have a medical condition that's not currently disabling, but that would have a very poor prognosis over 5 years, who could be excluded from ventilator treatment. And so, that's helpful in terms of recognizing it's not going to be only people with disabilities who are excluded. But I still just worry about that, the disproportionality.
Here's a question from a member of the audience. Does it change the disability rights analysis that the 5-year survival criteria in the PIT policy applies to those with and without disability? For example, many patients with cancer that severely limits their prognosis have no functional or intellectual disabilities until much later in their cancer course.
Yeah, so that's really getting at the point that I was just making, right? It's not going to, having a 5-year survival window that is taken into account, right? Not as much as the 1-year survival, but is still taken into account. It's going to mean that some people who don't currently have disabilities and who might survive to get out of the hospital would, if they receive ventilator care, would be denied the ventilator because they have some kind of diagnosis that, while not currently disabling, is bleak in the 5-year horizon, right? To my mind, I think that means it's not negatively affecting only people with disabilities, but the question becomes, and I think this, to my mind anyway, is a closed question. This is kind of from a legal perspective anyway, this seems like one of those questions that law professors love to torment their students with, right? Where do you draw the line? I am just concerned that with the 5-year survival window, you still have it disproportionately impacting people with disabilities. So if you look at the group of people who don't get ventilator care because of application of the policy, they're gonna be, people with disabilities are gonna be disproportionately represented among that group.
Sam, did you want to respond?
No, I mean, I think that all seems fair. I mean, particularly at the end, and I think, you know, it's also true that the longer the window that you're looking at, the more likely it is that your predictions are going to be hazy, and so that's a particular concern. And for some conditions, notice all of these conditions actually are disabilities under the ADA. I mean, you know, terminal cancer is almost certainly a disability under the ADA now. But for almost all, but for some conditions, we might do better at predicting than for others. And the ones that are most stigmatized, we might be especially bad about doing the prediction. So I'd be very worried about that. One thing I wanted to say about the scores too, you know, is I've looked at a number of these state plans that have scoring systems like this. And one of the concerns is, you know, you really, even if you think that that's a good way to do things, and I think, you know, legitimate questions have been raised about that, including by me. Of course, I think my questions are legitimate, but, you know, I think we've been discussing this here. Even if you think the scoring system is okay, and it's okay to have long-term or, you know, medium-term survivability as a piece of this, you really have to be careful looking at exactly how these different scores are weighted within the analysis. Because in some of the scores, you know, long-term survivability can end up, in some of these systems, longer-term survivability can end up swamping other factors. So you have to be really careful about both the ability to benefit in immediate term factors, number one, and these longer term factors. And some of the scoring systems, quality of life factors, actually can swamp the others. And I think we're all agreed that those aren't good factors to use. But so I think having a scoring system it really depends on the details. I mean, the devil is very much in the details here.
Question from a member of the audience. I know there is a lot of concern among the disability community around this matter. For those that work with people with disabilities, do you have any recommendations on how to address their concerns?
I mean, my number one recommendation is, you know, be in touch with your local advocacy groups. A number of the national and local advocacy groups and advocacy groups with networks around the country have been doing a lot of work to try to promote what some principles for a model policy would be. So a number of groups, including the ARC of the United States, which has been doing a lot in this area, issued a sort of set of principles that elaborates on what the Office for Civil Rights at HHS has said. I know a number of advocates are developing tools for local advocates to, you know, so national advocates are developing tools for local advocates to use in in assessing the protocols that are being used in your area and advocating with the folks who have those protocols. So connecting with them, connecting with your state protection and advocacy organization, your state chapter of the ARC, other organizations like that, I think is the crucial thing.
Yeah, Sam knows a lot more about the advocacy piece than I do, but the only other thing that occurs to me is that something that is distinctive about this situation is the fact that people who are receiving treatment in the hospital are cut off in many ways from their families or friends who would be natural advocates for them at a time when the decision's being made. And so as much as it adds to what's already a isolating and terrifying time for many people, I think that this idea of thinking in advance about how you're going to be able to advocate for yourself or have others advocate for you if you find yourself in that situation, that it's worth doing.
Another question from the audience. What are your thoughts on the executive order in New York granting immunity to healthcare workers for care related to COVID-19 from a disability rights perspective?
Yeah, so I haven't reviewed that order, so I'm not sure I could say anything about that.
Yeah, I haven't reviewed it either, and I think the question I would have would be, what is the scope of the immunity? So there could be, immunity from civil liability, for example, for malpractice. There could be immunity for criminal liability, potentially for manslaughter, and then there's questions about immunity from enforcement of disability discrimination law. So I think that's, all of those are of a concern. And some of them raise more concern than others from a disability rights perspective.
Would it be an accurate statement to say that a governor of a state can't confer immunity from federal civil rights statutes?
Yeah, absolutely.
Yes.
I'll ask one more question. The provision in the Alabama rationing criteria that you mentioned, Sam, that would exclude people with severe or profound intellectual disabilities. When I first saw that in your article, my initial knee-jerk reaction was, that's outrageous. And clearly it seems to be playing into devaluing the quality of life of people with intellectual disabilities. And then I began thinking, well, why would anybody in 2020 even consider such a limitation? And I began doing some research, and what I found was that in order to place somebody on mechanical ventilation, they have to intubate the individual. And in general, because we're dealing with people who are having airway problems, the folks who do the intubation want to do what's called awake intubation, which is much less risky than placing somebody under general anesthesia. But for people who don't understand what's going on, don't have the intellectual capacity to understand what's going on, they're going to physically resist awake intubation with somebody who has the cognitive capacity to understand the explanation of what's going on, why it is that I'm about to stick a tube down your throat. They can, with preparation, with explanation, help the individual understand, and then do awake intubation for patients with severe or profound intellectual disabilities. The only option would be performing the procedure under general anesthesia, which is much more risky in itself, which leads me to think that there is an explanation relating to survivability, the prognosis for survival, as to why they want to exclude folks who we would have thought this was just based on quality of life criteria, and which makes me wonder whether there are other aspects of the care involved in intubating and ventilating individuals and then weaning them from the ventilator that lay people like us may not be aware of, but that the doctors are saying this goes to the heart of the likelihood that it's going to be successful.
Yeah,
So,
I mean, sorry, go ahead, Mary, please.
Yeah, I mean, yeah, sorry, I would just say a couple of things about that. One is that I think it's, right, so policies have functional effects, how they're implemented. They also have expressive effects. So I think in any kind of scenario where, you know, my initial reaction, and I could be wrong, is that that's a generous reading of the policy. It may be accurate, but if that's the reason why people as a group who have some kind of intellectual disability are being excluded, it should be very transparent and explicit that that's why, for one thing. The second thing I would say is that I think kind of your description of why the conclusion might have been reached to exclude some folks raises another aspect of disability discrimination law, which is the need to make reasonable accommodations and modifications. So this could be an example of where, you know, for people who have some kind of intellectual disability that may lessen their ability to appreciate why someone's sticking a tube down their throat, then maybe it is a reasonable accommodation to say that they need to have some kind of sedative or general anesthetic that will ease that process, even if it means that it may affect their survival prospects.
We have a comment from a member of the audience who says, as a critical care physician, there's no good reason to exclude individuals with intellectual disabilities. There are plenty of ways to intubate that get around the issues that you raise. Red herring. I'm delighted to hear that. I'm just trying to explain to the extent that I can come up with an explanation for why that might have been included in the policy. We're out of time. Very much want to thank Sam and Mary for so generously donating your time and sharing your wisdom with the rest of us. We will be placing the video of this on YouTube after we have a chance to closed caption it or open caption it. And we thank you very much. So please, thank you for joining us.
Thanks.
Thank you.